of official immunity. Quote, this inquiry involves policies and principles that may be considered implicit in the nature of the president's office and a system structured to achieve effective government under a constitutionally mandated separation of powers, end quote. Fitzgerald, 457 U.S. at 748. Our analysis entails, quote, balancing the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch, end quote. Id at 754. We note at the outset that our analysis is specific to the case before us, in which a former president has been indicted on federal criminal charges arising from his alleged conspiracy to overturn federal election results and unlawfully overstay his presidential term. Reference 8. We do not address policy considerations implicated in the prosecution of a sitting president or in a state prosecution of a president, sitting or former. We consider the policy concerns at issue in this case in two respects. First, we assess possible intrusions on the authority and functions of the executive branch and the countervailing interests to be served as those concerns apply to former President Trump's claim that former presidents are categorically immune from federal prosecution. We conclude that the interest in criminal accountability held by both the public and the executive branch outweighs the potential risks of a chilling presidential action and permitting vexatious litigation. Second, we examine the additional interests raised by the nature of the charges in the indictment. The executive branch's interest in upholding presidential elections and vesting power in a new president under the Constitution, and the voters' interest in democratically selecting their president. We find these interests compel the conclusion that former President Trump is not immune from prosecution under the indictment.